Her children packed her one suitcase, not two. Not the trunk of things a woman accumulates across 78 years. One suitcase, the small tan one with the broken wheel, and they drove her 40 minutes from her home of 47 years. They passed the hardware store where Gerald bought paint, the school where their 3 children learned to read, and left her at the Millhaven Community Shelter on a Tuesday night in November. No hug, no explanation, no goodbye. Margaret Voss was 78 years old. As their taillights vanished, the deed to her house was already in motion. The garden. The walls she painted 3 shades of yellow. Everything she and Gerald built, $2.3 million in property and savings her children spent 2 years quietly plotting to steal. They believed she had nothing left to fight with, but when they carried her cedar chest through those shelter doors, they delivered the one thing that could destroy them. They thought they were burying her, but they didn't know she was a seed. Margaret Elaine Voss had lived at 14 Birch Street for 47 years, and in all that time she had never once let the rose bushes along the front fence go unpruned before the first frost. Every October, without fail, she would pull on Gerald's old canvas work gloves, the ones with a torn left thumb she had mended 4 times and refused to replace, kneel beside the fence and work her way down the row, clip by clip, bush by bush. She knew each one by the year she had planted it. The dark red climber nearest the gate had gone in the spring of 1979, the year Daniel was born. The pale pink ones along the far corner were Gerald's idea, 1991, the summer he retired. She talked to them while she worked. Neighbors had stopped finding this strange decades ago. The house itself was Victorian, wide front porch, tall, narrow windows, original hardwood floors that creaked in the specific language of a home that had been fully lived in. Gerald had repainted the exterior every 7 years like clockwork. After he died in 2011, Margaret did it herself. She hired a man for the latter work but chose the color alone, the same soft cream it had always been, because some things did not need to change. Her routine was precise. Coffee at 6:15. The newspaper, physical, folded in thirds the way Gerald had taught her. A walk to Caldwell Avenue and back before 8. Thursdays, she volunteered at the Millhaven Public Library, reshelving books in the local history section, a job she had held for 19 years without pay and without complaint. She was not a woman who asked for much, but she noticed everything. She had noticed, for instance, that Daniel had started calling more frequently in the past year. Not to talk. Daniel had never been a talker, but to ask questions about the mortgage, about the deed, about whether she had ever updated her will. She had answered him plainly each time and then set the phone down and stood at the kitchen window for a long moment looking out at the rose bushes before returning to whatever she had been doing. She did not say anything about those calls to anyone, but on the 3rd Sunday of October, when she knelt beside the fence to prune the roses before the frost came, she paused at the dark red climber by the gate, Daniel's rose. She had always called it privately, and instead of pruning it, she simply looked at it for a long time. Then she went inside and unlocked the cedar chest. The document arrived on a Wednesday morning, 3 weeks later, not by hand, not with a conversation.
It came in a standard white envelope, slipped through the mail slot at 14 Birch Street at 9:47 a.m., landed on the hallway floor between a grocery circular and a water bill, and sat there for 11 minutes before Margaret came in from the garden and picked it up. It was a notice of power of attorney activation. Legal language, dense and deliberate, informing Margaret Elaine Voss that her son Daniel James Voss had formally activated the durable power of attorney document she had signed 3 years earlier at Millhaven General Hospital, 2 days after a minor cardiac event when a nurse had placed a clipboard in front of her and Daniel had stood at the foot of the bed and said, "It's just for medical decision."
Standard procedure. She had believed him. The notice informed her that under the activated POA, Daniel had engaged a real estate attorney, a firm called Greer and Halston, based in Columbus, to begin the formal transfer of 14 Birch Street into a family trust controlled jointly by Daniel, her daughter Patricia, and her youngest, Kevin. The transfer was already filed. The buyer, a property development company called Hartwell Residential, had already submitted an offer of $890,000. The advance had already been accepted. Margaret read the document twice at the kitchen table. She set it down. She picked it up and read it a third time. Then she walked to the telephone on the wall, the old one, corded, cream-colored, the same phone that had been in that kitchen since 1988, and she called Daniel. He answered on the second ring. She read him the first paragraph of the notice aloud. There was a silence on the line that lasted 4 full seconds. Mom, he said, we've talked about this. The house is too big. You can't manage it alone. This is the responsible thing. You told me that document was for medical decisions, she said. It covers a broad range. Daniel. Another silence. Shorter this time. The paperwork is already filed, Mom. This is what's best for everyone. She placed the receiver back on the hook without responding. She did not cry. She stood at the kitchen window and looked at the rose bushes for exactly the amount of time it took her to make a decision. Then she pulled on her coat, walked 6 blocks to the office of Harold Fitch, the only attorney she had ever used, the man who had handled Gerald's will in 2011, and sat down in his waiting room with the notice folded in her coat pocket. Harold Fitch was sympathetic. He was also honest. The POA, as written, was broad enough to be defensible. Challenging it would take months and considerable money. The transfer, he told her quietly, was likely to proceed unless she could demonstrate the document had been obtained under false pretenses, which was difficult to prove without a witness to the original signing conversation. He would file an objection. He would try. But she needed to prepare herself. She walked home. She made dinner. She ate it. 3 weeks later, on a Tuesday evening in November, Daniel and Patricia arrived at 14 Birch Street together. Kevin did not come. Daniel carried a second suitcase up from the basement, the small tan one with the broken wheel, and set it open on the bed. Patricia stood in the doorway of the bedroom and did not look at the walls. We found a very good place, Patricia said. It has activities. Margaret packed what fit. She left the rose bushes unpruned. Daniel carried the cedar chest to the car without asking. It was heavy enough that he had to set it down twice on the front path. He did not ask what was in it. He assumed it was linens. They drove 40 minutes in near silence and pulled into the parking lot of the Millhaven Community Shelter at 8:20 p.m. Daniel carried her suitcase to the front desk. Patricia signed the intake forms. They left before the shelter director came out from the back office. Margaret sat on a cot in the intake room, still wearing her coat. At 9:15 a.m. the following morning, Carol Baines, the shelter director, a woman who had worked in social services for 31 years and who followed intake protocol with the kind of quiet discipline that rarely gets noticed until it matters enormously, began processing the donated items that had arrived the previous evening. She lifted the cedar chest onto the receiving table. She removed the folded linens from the top. She pressed her palms flat against the interior base panel the way she always did, checking the structural integrity of donated furniture before storage. The panel gave slightly. Unevenly. She pressed again. Felt the edge of something rigid and metal beneath the wood. She called for Thomas, her maintenance supervisor. It took him 6 minutes and a flathead screwdriver to reveal what was bolted underneath. A fireproof metal lockbox, matte gray, military grade, with a single brass keyhole. Carol carried it to Margaret. Margaret looked at it for a long moment. Then she reached inside the collar of her blouse and pulled out the chain she had worn for 31 years. The small brass key caught the light from the intake room window as she lifted it over her head. The lockbox opened on the first turn, Inside was a single manila envelope, sealed with red wax, the surface marked in handwriting Margaret had not seen in 14 years for Margaret. When the time comes, she opened the envelope. She read the first page slowly, and then the second, and then she sat very still for a moment that seemed longer than it was. Her hands, which had not stopped trembling since Tuesday night, went completely still. She folded the document closed. She looked up at Carol Baines, who was standing 3 feet away, pretending to review her clipboard. "I need a lawyer," Margaret said. "A good one. Tonight." Carol Baines had seen a great many things in 31 years of shelter work. She had seen people arrive with nothing and leave with less. She had seen families dissolve in real time across her intake desk. She had seen grief in every shape it takes. Loud grief, silent grief, the kind that sits in a plastic chair and stares at a water-stained ceiling tile for 6 hours without blinking. She had never seen anything quite like the expression on Margaret Voss's face when she closed that envelope. It was not relief. It was not triumph. It was something quieter and more dangerous than either of those things. It was the expression of a woman who had just remembered exactly who she was. Carol set down her clipboard. "I know someone," she said. His name was Robert Ellison, 54 years old. Estate and property law, 17 years in private practice out of a 2-room office on Caldwell Avenue, 4 blocks from Margaret's house. As it happened, with a reputation in Millhaven for being the kind of attorney who read every word of every document before he signed anything, and who charged his elderly clients exactly half his standard rate because, as he had told Carol Baines once at a library fundraiser, "Most of the people who need me most are the ones who can afford me least." Carol called him at 9:47 p.m. He arrived at the shelter at 10:35 p.m. with a legal pad, a thermos of coffee, and no appointment. He sat across from Margaret at the small table in Carol's office, and she handed him the manila envelope without preamble. He read the first document, then the second. Then he went back to the first and read a specific clause 3 times, slowly, with his index finger moving beneath the lines the way a man does when he wants to be absolutely certain he is reading what he thinks he is reading. He set the papers down on the table. He looked at Margaret over the top of his reading glasses. "Miss this?" "Voss," he said, "do you understand what this is?" "My husband explained it to me when he had it drawn up," she said, "in 1987. I understood it then. I believe I still do. Then you know that your son cannot touch this property." "That no one can, I know," she said. Gerald was a careful man. Robert Ellison picked up his legal pad and wrote 4 words at the top of the first page. Then he looked up. "I'll need to file first thing in the morning," he said, "before the courthouse opens, if possible. Are you prepared to move quickly?" Margaret folded her hands on the table. "Mr. Ellison," she said, "I have been waiting 31 years for this conversation. I am prepared." Margaret slept 4 hours that night on the shelter cot. Still in her coat. At 6 a.m., she was sitting upright, the manila envelope on her lap, watching the gray November light come through the high intake room window. Carol brought her coffee, real coffee, not the institutional kind, and a piece of toast with butter. And Margaret ate it at the small table with the careful, deliberate attention of a woman conserving her energy for what was coming. She had $23 in her coat pocket, a half-used book of stamps, her reading glasses in a case Gerald had given her in 1999 with her initials pressed into the leather, the brass key on its chain, and the envelope that was the complete inventory of what Margaret Voss owned on the morning of November 14th. Everything else, the house, the furniture, the 47 years of accumulated living, was legally in motion, being processed by a firm in Columbus that had never met her and had no particular interest in doing so. She opened her reading glasses case, removed a folded piece of paper from behind the lens cloth, a habit she had maintained for years, keeping a small notepad sheet there for grocery lists, and she began to write. Not a grocery list, a sequence. What needed to happen first, second, third. She wrote in the small, precise handwriting of a woman who had kept household accounts by hand since 1971 and had never once made an arithmetic error that Robert Ellison arrived at 7:50 a.m. They walked to the courthouse together. He filed the emergency motion to freeze the property transfer at 8:31 a.m., 1 minute after the clerk's window opened. The cedar chest stayed in Carol's office. Margaret asked that no one move it. The second person to help Margaret Voss was someone no one expected. Least of all Margaret, her name was Diane Okafor, 39 years old, originally from Akron, and for the past 4 years the senior property records clerk at the Millhaven County Courthouse, a position of almost invisible institutional power that most people dramatically underestimated right up until the moment they needed something. Diane had processed Robert Ellison's emergency filing that morning. She had also, 48 hours earlier, processed the original transfer filing submitted by Greer and Halston on Daniel Voss's behalf. She had flagged it internally at the time, not because anything was technically incorrect, but because the signatory on the activating POA document did not match the notarization date on the supporting medical authorization. A minor discrepancy. The kind of thing that gets overlooked in a busy office on a Friday afternoon. Diane had not overlooked it. She had made a note in the file margin in red ink and stapled a yellow query slip to the back of the document, waiting for clarification that never came. When Ellison's emergency motion arrived and Diane pulled the original file to cross-reference, she found her own red note looking back at her. She walked the file to her supervisor. Her supervisor called the county attorney's office. By noon, the transfer filing had been placed under administrative review, separate from and in addition to Ellison's court motion. Diane came to find Robert Ellison in the courthouse corridor at 12:45 p.m. She handed him a photocopy of her red ink note and the yellow query slip. "I don't usually do this," she said, "but that notarization date is wrong by 11 days. Somebody made a mistake, or somebody made a choice." "I thought you should know which." Ellison looked at the photocopy for a long moment. "Mrs. Voss should know your name," he said. "She doesn't need to know my name," Diane said. "She just needs to win." She walked back to her office. Ellison stood in the corridor, holding the photocopy, and revised his entire legal strategy on the spot. Margaret could not go home. The house was under active legal dispute, and Greer and Halston had already changed the locks on behalf of Hartwell Residential, citing their client's financial interest in the property's security during the dispute period, a move that was legally questionable but practically immediate. She stayed at the shelter. Carol gave her the small room at the end of the east corridor that was normally reserved for families. It had a table, a window, and a lamp, and Margaret set up her operations there with the focused efficiency of someone who had run a household for half a century and understood that a space becomes functional the moment you decide it is. The cedar chest was moved to her room. She kept it locked. The manila envelope lived on the table beside her reading glasses. She worked with Robert Ellison every morning from 9 to 11 in Carol's office. He brought documents. She read every word of every one, and twice she caught clauses he had not flagged, small things, precise things, the kind of detail that only someone who has spent a lifetime reading the fine print of domestic life ever notices. He stopped being surprised by the third day and started bringing 2 copies of everything, one for him, one for her. The town of Millhaven, for its part, had opinions. The Voss family had been in Millhaven for 2 generations. Daniel Voss was a member of the Rotary Club. He coached youth soccer for 6 years in the 90s. His name was on the donor wall at the library. When word spread, as it does in a town of 11,000 people, through the specific telephone network of grocery store conversations and church parking lot exchanges, the initial current of sympathy ran, not entirely, in his direction. She was elderly. She was perhaps confused. These things happened in families. It was sad, certainly, but Daniel had always seemed like such a reasonable man. Margaret heard some version of this sentiment secondhand through Carol. She listened to it fully. Then she went back to her table and continued reading documents. She did not explain herself to anyone who had not asked her a direct question. She did not complain. She ordered a legal notepad from the pharmacy 2 blocks away, paid for it with $4 of her $23, and filled it front to back within a week.
On the morning of November 21st, 1 week after Margaret's arrival at the shelter, a courier delivered a document to Robert Ellison's office on Caldwell Avenue. It was a motion filed by Greer and Halston on behalf of Daniel Voss, Patricia Voss, Carmichael, and Kevin Voss, requesting that the court appoint a formal legal guardian for Margaret Elaine Voss on the grounds of diminished cognitive capacity and inability to manage her own affairs, as evidence the filing claimed by her voluntary residence at a community shelter and her apparent confusion regarding previously signed legal documents that if the guardianship motion succeeded, they were trying to erase her legal standing entirely. If the guardianship motion succeeded,
she would lose the right to instruct her own attorney. Robert Ellison's representation would become legally questionable. The trust document, even with Gerald's spendthrift clause, could potentially be administered by a court-appointed guardian who answered, in practice, to the family. It was a precise and devastating escalation. Greer and Halston had clearly anticipated the emergency motion. They had prepared this as a counter. Someone in that firm had thought carefully about Margaret's vulnerabilities, and they had found the right door to knock on. Ellison drove to the shelter and sat down across from Margaret at her table. He placed the guardianship motion in front of her without comment and watched her read it. She read it twice. She set it down. "They're saying I'm incompetent," she said. Yes. Because I'm living in a shelter. Yes. Which I'm living in because they put me here. Yes, Ellison said. I know. Margaret looked at the document for another moment. Then she picked up her pen and wrote 3 words on her legal notepad, underlined twice, and turned it to face Ellison. The words were cognitive evaluation. Immediately. If they want to question my mind, she said, let them question it in front of a doctor with credentials and a written report. Schedule it today. I want the results in the court file before they can blink. Ellison scheduled the evaluation for the following morning with Dr. Patricia Onwu, a neuropsychologist at Millhaven General who had been administering cognitive assessments for 22 years. Margaret scored in the 94th percentile for her age group across every tested category. Dr. Onwu noted in her written report, in the section reserved for additional clinical observations, that the subject had, unprompted, identified 2 ambiguous grammatical constructions in the written assessment instructions and politely pointed them out before beginning the test. Ellison filed the report with the court. The same afternoon the results came in. He attached a 2-paragraph motion opposing the guardianship filing and requesting sanctions against Greer and Halston for what he characterized, in precise legal language, as a frivolous and retaliatory filing designed to obstruct a vulnerable adult's access to justice. The guardianship motion was denied 6 days later, but the damage of the week had been real. The legal fees were accumulating. The freeze on the property transfer meant the trust funds remained technically inaccessible until the underlying fraud case resolved. Margaret had $11 left. She had asked Carol to advance her nothing. She sat at her table that night and looked at the manila envelope, and then at the cedar chest, and then at the window, where the November dark had come down hard and early over Millhaven, and she made a second list on a fresh sheet of her notepad. This one had 4 items on it. She folded it in half and placed it under her reading glasses case. She was not waiting. She was calculating. Robert Ellison arrived on the morning of November 28th, 2 weeks after the cedar chest had been opened, carrying a folder he set on the table with the particular careful flatness of a man placing something breakable on a surface. "I need to tell you what happened yesterday," he said. He opened the folder. The evening before, Daniel Voss had been sitting in the Columbus offices of Greer and Halston when his personal cell phone rang. It was First Meridian Bank of Ohio calling from their fraud and compliance division. The trust document that Robert Ellison had filed with the court contained, as the bank's own compliance team had now reviewed and confirmed, a spendthrift provision with an active clawback mechanism, a clause written into the 1987 trust by Gerald Voss's original attorney, a man named Warren Chu, who had since retired to Sarasota but whose legal work, it turned out, was of the airtight variety. The provision did two things. First, it automatically voided any transfer of real or personal property connected to the Voss estate if that transfer was executed without the direct, witnessed, notarized consent of the living beneficiary, Margaret. This was not a debatable interpretation. It was written in unambiguous declarative language across 14 lines of the original trust document. The Birch Street transfer was void. Not voidable. Void. It had been legally void from the moment Daniel filed it second, and this was the clause Ellison had pressed his finger beneath 3 times on the night he first read it. The provision included an automatic notification requirement. Any financial institution holding accounts connected to the trust was legally obligated to flag and freeze any transaction that appeared to contravene the beneficiary's protected status. First Meridian had flagged the advance payment.
The $180,000 that Hartwell Residential had transferred to Daniel Voss as a good faith advance on the property purchase, money Daniel had already partially distributed between himself, Patricia, and Kevin, was now subject to immediate recovery. While Daniel sat in that Columbus office absorbing this information, his phone rang a second time. It was the legal representative of Hartwell Residential. Hartwell had been informed by their own attorneys that the property transfer was fraudulent, that the seller had no legal standing to execute the sale, and that the $180,000 advance had been received under false pretenses.
Hartwell was filing a civil suit against Daniel Voss personally for the full return of the advance plus consequential damages, which their attorneys had preliminarily estimated at $340,000 total, pending a full accounting of costs incurred in reliance on the fraudulent transfer. Daniel Voss owed $340,000 he did not have. The house he had tried to sell was still his mother's. The POA he had used to take it was under criminal investigation for fraudulent procurement, and his mother was sitting in a shelter 4 blocks from the house she owned, reading legal documents with a precision that was, at this point, genuinely alarming to everyone in the Greer and Halston office who had reviewed her case notes. Ellison laid the folder flat and looked at Margaret. She read every page. She looked up. Gerald always said that Warren Chu was the most careful man he had ever hired, she said. He was right. The trust funds are now fully accessible, Ellison said. The fraud finding clears the hold. We can move to retitle the house in your name within the week. Patricia and Kevin have already contacted me separately. They are not contesting anything. Kevin sent a written apology this morning. Margaret looked at the envelope on the table. She looked at the cedar chest. What about Daniel? She said, Daniel, Ellison said carefully, is going to need his own attorney. The retitling hearing was scheduled for December 9th in the Millhaven County Courthouse, Courtroom B, before Judge Annette Carroll. Daniel Voss appeared with a new attorney, a man named Fowler, from a smaller firm, since Greer and Halston had quietly withdrawn from his representation 10 days earlier, citing a conflict of interest. Fowler filed a last-minute motion arguing that the 1987 trust document had never been properly disclosed to the estate's co-heirs and therefore could not be considered a valid governing instrument without additional probate review. Judge Carroll read the motion. She read it for approximately 90 seconds. She set it down. She asked Fowler 3 questions, each more specific than the last, about irrevocable trust law in the state of Ohio. Fowler answered the first adequately and the next 2 with increasing difficulty. On the third, he asked to consult his notes. Judge Carroll gave him 45 seconds. His answer did not improve. She denied the motion from the bench. She then issued the retitling order, signed it in front of both parties, and handed the certified copy to Robert Ellison directly. She looked at Margaret, who was sitting at the plaintiff's table in her good coat, the charcoal wool one she had packed in the tan suitcase with the broken wheel, with her hands folded and her reading glasses in their initialed leather case on the table in front of her. Mrs. Voss, Judge Carroll said, "Your house is yours." Margaret picked up her reading glasses case. She put it in her coat pocket. She stood, nodded once to the judge, and walked out of the courtroom. In the hallway, Ellison fell into step beside her. He was smiling. She was not, quite, but something in the set of her shoulders had changed. Something that had been braced against the weight that was no longer there. "What would you like to do first?" he asked. Margaret looked at the courthouse doors at the end of the corridor, the gray December light coming through the glass. "I'd like to go home," she said. "And then I'd like to call a contractor." The contractor's name was Pete Salazar. 51 years old, third generation Millhaven, with a company called Salazar and Son that had been operating out of the same garage on Teller Road since 1987. The same year Gerald Voss had signed the trust document that was now sitting in a courthouse file folder with Margaret's name on the cover page. Pete had re-roofed 14 houses on Birch Street over the years. He knew the Victorian on the corner. He had always admired its bones. He walked through it with Margaret on December 11th, 2 days after the retitling order was signed, carrying a yellow notepad and a flashlight for the basement inspection. Hartwell Residential had changed the locks and had a property management company do a walkthrough during the dispute period. They had not damaged anything, but they had removed several of Margaret's personal items, photographs, a small writing desk from the upstairs bedroom, the cream-colored telephone from the kitchen wall, and cataloged them as miscellaneous contents of disputed property, currently being held in a storage facility in Columbus. Margaret noted each missing item on her own notepad as she moved through the rooms. She did not stop moving. She checked the rose bushes along the front fence before she went inside, still there, unpruned, ragged from the November frost, but alive, and she checked them again when she came back out. "What are we doing with the place?" Pete asked, standing on the front porch with his notepad. "Restoring it," Margaret said. "Exactly as it was. Every room. That's going to cost. I'm aware of what it will cost," she said. "I'd like a full estimate by Friday." Pete Salazar had been a contractor for 28 years. He recognized the specific tone of a person who has already made every decision and simply requires execution. He had his estimate on Robert Ellison's desk by Thursday afternoon. The trust funds, $2.3 million, dormant since 1987 and accruing interest across 38 years of careful inactivity, had been released in full following the fraud determination and the retitling order. After legal fees, after the cost of the cognitive evaluation, after the miscellaneous expenses of 6 weeks lived out of a shelter room with $11 in a coat pocket, Margaret had more money than she had ever had access to in her life. Gerald had built that account slowly, deliberately, across the years of their marriage. $1 here, a deposit there, the kind of quiet financial patience that goes unnoticed until it becomes, all at once, undeniable. She authorized the full restoration. She also, through Robert Ellison, filed a formal recovery claim against Hartwell Residential for the return of every removed personal item. The photographs came back in a cardboard box by December 19th. The writing desk arrived on December 22nd, wrapped in moving blankets. The cream-colored telephone was the last thing returned on December 26th, and Margaret rehung it on the kitchen wall herself, on the same hook and the same position where it had been since 1988. The town of Millhaven revised its opinion of the situation across the month of December, the way small towns revise their opinions, not all at once, not with any formal announcement, but in the gradual accumulation of small conversational corrections that eventually add up to a new consensus. It began at the library. Margaret returned to her Thursday volunteer shift on December 16th, her first Thursday back since October. She arrived at 9 a.m., signed in at the circulation desk, collected her reshelving cart, and went to work in the local history section without comment or ceremony. By 10:30 a.m., 4 of her fellow volunteers had found reasons to be in the local history section simultaneously. By noon, the library director had brought out a coffee cake from the break room and placed it on the circulation desk without explanation. Nobody made a speech. Margaret would not have wanted a speech, but when she left at 1 p.m. with her coat buttoned and her reading glasses case in her pocket, the woman at the front desk, a young part-time volunteer named Sophie, who had started in September and had never met Margaret before that day, said, "Same time next Thursday, Mrs. Voss?" "Same time," Margaret said, and walked out into the December cold from the library. The correction spread. The grocery store on Caldwell Avenue, where Margaret had shopped for 40 years, where the manager knew she bought the same 7 items every week. The hardware store on Route 9, where Gerald had bought his paint, and where the current owner still had a running account under the Voss name that had never been formally closed.
The church on Elmwood Street, where Margaret had sung in the choir for 22 years before Gerald's illness made Sunday mornings complicated, and where the choir director sent a handwritten note to the shelter arriving with some delay after Margaret had already gone home that Carol Baines forwarded to Birch Street with a yellow sticky note that read, "Thought you'd want this." Margaret read the note at her kitchen table with the cream-colored telephone on the wall behind her and the restoration work happening in controlled sections around her. Pete Salazar's crew working room by room, starting at the back of the house and moving forward.
So that Margaret always had a finished space to occupy while the work continued. She pinned the choir director's note to the small corkboard beside the refrigerator, where she had always kept the things she wanted to remember. Daniel Voss, in the weeks following the courthouse hearing, had retained Harvey Fowler on a continuing basis to manage the civil proceedings Hartwell Residential had initiated against him. The $340,000 claim was proceeding through the courts. He had also received a formal notification from the Millhaven County District Attorney's Office that the fraudulent procurement of the POA document was under active criminal investigation following Robert Ellison's filing and the notarization discrepancy Diane Okafor had identified in the courthouse records. Patricia Voss Carmichael had, as Ellison reported, signed a full statement of non-contest and had sent a second written communication to Margaret, longer than the first 4 pages, handwritten, that Margaret received. Read in full at her kitchen table, folded carefully, and placed in the cedar chest. She did not respond in writing. She would respond when she was ready, in the way she chose, on her own schedule. Kevin Voss had driven to Millhaven on December 18th and sat in the parking lot of the Millhaven Community Shelter for 22 minutes before going inside and asking Carol Baines if he could speak to his mother. Carol told him his mother was no longer at the shelter. She did not give him the address. She told him to write a letter. He did. It arrived at Birch Street on December 23rd, 2 pages, and Margaret read it at the kitchen table on Christmas Eve morning with her coffee. She put it in the cedar chest beside Patricia's that she was not ready. But she was not closed. Those were different things, and Margaret Voss understood the difference precisely. The renovation of 14 Birch Street was completed on January 14th. Pete Salazar walked through every room with Margaret for the final inspection, notepad in hand out of habit, though there was nothing left to write. The hardwood floors had been refinished to their original color. The kitchen had been repainted the exact yellow. Margaret had kept a paint chip taped inside her copy of the 1994 household accounts ledger for no reason she could have articulated, but there it was, and the wide front porch had been replanked and sealed against the winter. The last thing installed was the brass plaque beside the front door. Margaret had ordered it herself through a metalwork shop in Columbus with specific instructions about the font and the size and the finish. Pete's crew mounted it on January 14th at 2:15 p.m. Pete stepped back and read it. He looked at Margaret. She was looking at the plaque with the expression of a woman who has waited a long time for a thing to be exactly right and is now confirming that it is the Voss House Est. 1971. Still standing. That'll do, Pete said quietly. Margaret pulled on Gerald's old canvas work gloves, the ones with the torn left thumb, mended 4 times, retrieved from the box of returned personal items, and walked to the front fence to prune the rose bushes. They were overdue. She had a great deal of work to do. But she was home. The letter from the district attorney's office arrived on February 3rd. Daniel Voss was formally charged with 1 count of fraudulent procurement of a legal instrument and 1 count of elder financial abuse under Ohio Revised Code Section 2913-02. Charges that carried, at the higher end of sentencing guidelines, up to 5 years and a permanent civil judgment. Harvey Fowler issued a brief statement to the Millhaven Gazette describing his client as committed to cooperating fully with the process. The Gazette ran the story on page 3, below the fold. By the following morning, it was the most read article on their website in 14 months. Robert Ellison called Margaret when the charges were filed. She thanked him, set the phone back on the hook, and went to prune the section of the rose fence she had not yet finished. She had not spoken to Daniel since the phone call in November, the one where he had said, "This is what's best for everyone," and she had placed the receiver down without responding. She had not sought the conversation. She had not avoided it either. She had simply continued doing what needed to be done in the order it needed to be done, and this was the next thing. He called her on February 11th. She was at the kitchen table with her coffee when the cream-colored telephone rang. She looked at it for 2 full rings. Then she picked up Mom. His voice was different, smaller. The particular smallness of a person who has been standing in a large open space of their own making and has finally understood how exposed they are. Daniel, she said. A silence. Long enough that she could hear traffic on his end. He was not at home or not in a quiet room. He was somewhere public or moving, the way people sometimes call from cars when they need the momentum of motion to say something they cannot say standing still. I don't know how to. He stopped. Started again. I told myself it was practical, that you couldn't manage the house, that it was the responsible thing. I know what you told yourself, Margaret said. Another silence. Was any of it true? He asked. And she understood from the way he asked it, not as a defense, not as a reframing, but as a genuine question, the kind that cost something to ask, that he was not calling to negotiate. He was calling because he had run out of other things to do. Margaret set down her coffee cup. The house was never the problem, Daniel, she said. You stopped seeing me. You looked at me and saw a liability, an inconvenience, something that needed to be managed and resolved. You stopped seeing me as a person. She said it without heat, without tears, in the same clear, even voice she had used to read the POA, notice aloud to him in November, precise and irrefutable, the voice of a woman who has chosen her words because they are accurate, not because they wound. I know, he said. Your father built that trust for one reason, she said, not to protect the money. The money was secondary. He built it because he knew that the day might come when I would need something that couldn't be argued with or taken away or managed by someone else's decision. He gave me that 31 years ago. And he was right too. The traffic sound on Daniel's end had stopped. He was standing still now. I'm not going to tell you what happens next with the legal case, Margaret said. That's between you and the court and whatever choices you make going forward. I'm not the one who can fix that for you. I know, he said again. His voice was very quiet, but I want you to understand something, she said. I'm still here. I'm in this kitchen. The roses are coming back. Gerald's house is still standing. You did not finish me. Do you understand that? A long silence. Yes, Daniel said. Good, Margaret said. Then we have nothing left to say today. She placed the receiver back on the hook. She sat at the table for a moment, her hands flat on the wood surface, looking at nothing in particular, at the yellow wall, at the corkboard with the choir director's letter pinned to it, at the window where the February light was coming in thin and cold and honest. Then she picked up her coffee. She finished it. She did not forgive Daniel Voss on February 11th. Forgiveness was not a single phone call or a single moment of acknowledged damage. It was a long piece of work, and Margaret knew how to do long pieces of work. She would get to it in her own time, the same way she got to everything, steadily, precisely, without rushing toward a resolution that hadn't been fully earned. What she did on February 11th was something different from forgiveness, and in some ways more powerful. She closed the door on his version of her, the version that was diminished and manageable and finished. She closed it quietly, the way you close a door on a room you have cleaned out and no longer need, and she turned back to her kitchen and her coffee and her life. The Voss House, Est, 1971. Still standing, she had put those words on the plaque for herself. Not for the town, not for the record, for herself. And they were true. Spring came to Birch Street the way it always had, slowly at first, a pale loosening of the cold, a softening of the light across the front porch in the early mornings, and then all at once, the way Margaret had always loved it, the way it arrived every year, like something that had simply been waiting for permission. She was in the garden by the first week of March. Gerald's canvas work gloves. The same pair, the left thumb mended a fifth time now, with a slightly darker thread, because the hardware store had been out of the exact match, a discrepancy that bothered her less than she would have expected. The rose bushes along the front fence had come back stronger than she had anticipated. The dark red climber by the gate, Daniel's rose, she had always called it privately, had put out 3 new canes over the winter, reaching upward along the fence wire with the particular stubbornness of something that had been cut back hard and responded by growing. She pruned it carefully. She always had. Carol Baines came for coffee on a Thursday morning in April and sat at the kitchen table where Margaret had once read a legal notice that had tried to end her life as she knew it. They drank coffee and talked about nothing urgent, the library's new director, the hardware store's expanded hours, a robin that had built a nest in the eave above the shelter's back door. Carol did not stay long. She had work. Margaret walked her to the front gate, and they stood for a moment in the April light, easy and unhurried, the way 2 people stand when there is nothing left between them that needs resolving. Robert Ellison sent a card in May. Short, professional, genuine. Margaret wrote back on her good stationery. Kevin came in June. He sat on the front porch, and they drank lemonade, and Margaret asked about his daughter, 7 years old, a detail she had not forgotten, and he answered carefully, gratefully. The way a person answers when they are aware they are being given something they are not certain they deserve. She let him come back the following month. She was not finished forgiving. But she had started on a Tuesday morning in late May. She knelt beside the dark red climber at the gate and found the first bloom of the season. Small, not yet fully open, the color of something that had survived the winter and knew it. She did not need to say anything about that. Some things speak entirely for themselves.